The Supreme Court today struck out President Muhammadu Buhari and the Attorney General of the Federation suit challenging Section 84, subsection 12 of the Electoral Act. And INEC published names and particulars of candidates for the 2023 elections. Senate President Ahmed Lawan, Governor Umahi of Ebonyi, and Godswill Akpabio, former ministers' names are conspicuously missing. Many thanks for joining us, everyone. Good evening, wherever you may be watching. This is Politics Today, live on Channels Television. I'm Sean Wakimaloye. Let's get to it. So much to talk about and so much revelation coming. Just as you see on the bottom strip of your screen right there, the news just coming in, information reaching us from the different states of the Federation based on what INEC has released, the publication of the names and particulars of candidates. There are four major things that have come out to us tonight. As the names of the Senate President, it may not be on the ballot this time around because his name is missing. The name of the governor of Ebonyi State, Dave Umahi, and the name of the former minister of the Niger Delta, Godswill Akpabio, and of course the name of some of the PDP candidates in Edo State are conspicuously missing. We get into that and what could have led to all of that. Stay with me, everyone. Of course, the Supreme Court judgment today also revealing that the suits that the federal government took to the Supreme Court has been struck out. We'll find out details on that, but stay with me. We get into all of that in a moment. Let's also let you know that the Supreme Court today struck out President Muhammadu Buhari and the Attorney General of the Federation suit challenging Section 8412 of the Electoral Act. The case was expunged on the grounds that it lacks the jurisdiction to entertain the suit and is an abuse of court process. Earlier, a notice for the judgment delivery was served on President Buhari and the National Assembly, inviting them to appear before the court for the judgment. The President and his Minister of Justice, Abubakar Malami, had filed a suit at the Supreme Court seeking an interpretation of the controversial clause in the Electoral Act Amendment 2022. In the suit filed on the 29th of April, President Buhari and Mr. Malami, who are the plaintiffs, listed the National Assembly as the sole defendant. In the suit marked SCCV 504-2022 and filed on the 29th of April 2022, President Buhari and Mr. Malami sought an order of the Apex Court to strike out a section of the Electoral Act which they argue was inconsistent with the nation's constitution.
I cannot but to salute the courage, the industry of my noble lord for doing justice to this matter. Cases do come. We have filed our reaction, and my noble lords agree with our reactions to the point that this is not the kind of the matter that should be brought to the Supreme Court, particularly where the president happened to be the part of the maker of that law. You can't appropriate at the same time appropriating. You cannot be seen to have done something and at the same time turn around to ask that what you have done should be set aside in this kind of procedure.
Supreme Court have delivered their judgments, and being the apex court, everybody is bound by it. Unfortunately, the merit of the case was not determined. The objections of the defendant was upheld. Where the first and second defendant were held not to have sufficient locus to bring the action and to invoke the original jurisdiction of the Supreme Court on the matter. And well, having made that point, they felt there was no need for them to determine the merit of the case, which is on the constitutionality of Section 8412 of the Constitution, of the Electoral Act. So that is it for now. There's nothing anybody can do about it. We are bound by that decision.
Lawyers to the plaintiff and the defendants, you can hear them at the Supreme Court. Because the Supreme Court is an abuse of court process. What does this mean? But beyond all of that is the implication of that ruling or the position of the Supreme Court on the electoral process, the election of 2023, the preceding processes before now. We'll get into that, but let's serve you with some of your political roundup stories and we get talking.
Against the backdrop of the huge number of people seeking to be registered by the Independent National Electoral Commission (INEC), the Commission says it's disposed to extend the deadline for the ongoing continuous voter registration exercise from its initial closing date, which is June the 30th. INEC National Commissioner on Publicity and Voter Education, Mr. Festus Okoye, told Channels Television that the Commission will not stop the ongoing exercise by the end of June and cannot announce a new date until the case challenging INEC's decision to stop the continuous voter registration in June is disposed of.
The Commission is favorably disposed towards an extension of the period for this registration. But that will only be announced by the Honorable Chairman.
Governor Umar of Interior of Adamawa State has reiterated his commitment towards the free education policy of his administration aimed at improving the standard of education in the state by providing instructional materials in all secondary schools across the state. The governor gave the commitment in Yola, the Adamawa State capital, while flagging off the distribution of instructional materials to all the schools across the state. The former senator representing Rivers Southeast in the National Assembly, Magnus Abe, has launched a political movement tagged Project SMA 2023 to gather more support for his political ambition. The project will see those who believe in the leadership of Senator Abe visit the 319 wards in the 23 local government areas of Rivers State to register their data.
It is Rivers people that will take the decision as to who will govern them. All right. And you are the Rivers people.
Ahead of the 2023 governorship elections, the African Democratic Congress has unveiled entertainment sensation Ms. Tonto Dike as the deputy governorship candidate of the party in Rivers State. The national chairman of the party, Mr. Rafo Kinwosu, who unveiled Ms. Dike at the headquarters of the party in Abuja, says the youths of Nigeria deserve to lead the country in order to transform the people. The national chairman also presented a certificate of return to the governorship candidate of the party.
The governors we have are merchants who are doing business. They don't know that they are sitting there as a state officer. As state officer, number one and number two have almost equal rights to take charge at any given time.
Women across the nation have been admonished to actively participate in politics rather than depend on vote buying, voter inducement, and other electoral vices. This was critically discussed at the town hall meeting with election and governance stakeholders and non-governmental organizations at Justice Development and Peacemaker Center in Osogbo, the Osun State capital.
We call on all female registered voters who have not collected their PVCs to visit the nearest Independent National Electoral Commission offices to collect their PVCs.
And Ahmed Sani Keitafi, an APC House of Representatives aspirant in Yobe State, has filed a lawsuit at the Federal High Court, Damaturu, challenging the party and two others for alleged non-conduct of primary elections for the Bade Jakusko Federal Constituency seat, Yobe State. The case, which came up for mention today, was presided over by Justice Fadima Aminu and adjourned to 21st of July 2022.
Thank you so much, everyone, for staying with us. So let's get into it. So much to talk about and some sort of breaking news that are coming in based on the provisions of the Independent National Electoral Commission, INEC, and its timelines and schedule of 2023 general elections. The umpire is expected to publish the names and particulars of candidates vying for the different positions after all primaries and all processes have been done. The commission today did that, and conspicuously, the names of former Minister of Nigeria Outer Affairs, Godswill Akpabio, the name of Governor of Ebonyi State, Dave Umahi, and that of Senate President Ahmed Lawan were missing on the list. Well, those who are expecting that those names might be on the list because of the controversies that have trailed the processes, the elections and the primary leading up to this moment, were perhaps shocked that this is not happening. Well, there are reasons for that, which we'll be hearing tonight from INEC. There have been controversies over the names of these persons who were seeking to contest other positions. let's get a sense of what is mean. The Supreme Court judgment one, the issue of the possibility of extension of the CVR exercise. If you are yet to collect your PVC or you're yet to register, what are the hopes and that you have to be able to get to do that? And of course, these names that are released, what are the implications? I'm being joined by the National Commissioner of INEC in charge of voter education and publicity, Mr. Festus Okoye, who is here with us in our Abuja studio. Thank you so much, Mr. Okoye. On such a short notice, as soon as I got that information, I reached out to you and you were magnanimous enough to be able to come into the studio. Many thanks for that. Let's get it clearly. Speaking to some of my colleagues across the state, when we're monitoring, as soon as we got information that you have pasted the names and particulars of candidates who were successful in the primaries, but obviously there are contentions. One concerning the Senate President and Mr. Mashina. Also, that's in Yobe State. The name of Governor of Ebonyi State, Dave Umahi, and the name of the former Minister of Niger Delta. Those names were missing. Are there explanations to this?
Well, the Section 29, subsection 3 of the Electoral Act 2022 obligates the Commission to publish the names of validly nominated candidates within a period of 7 days after the receipt of their nominations. So if a candidate has been validly nominated and if a candidate has passed through valid party primaries and the name of the candidate has been submitted by the leadership of the political party concerned, then the Commission is under a constitutional and legal obligation to publish such a name, to publish the particulars of such an individual or candidate. But if a political party submits to the Independent National Electoral Commission the name of a candidate that did not emerge from party primaries or did not emerge from valid party primaries, the Commission is not obligated to publish the name of such a candidate.
Section 84, subsection 13 of the Electoral Act gives INEC the power to carry out, to reject any names that is not relevant or that is not consistent with what you monitored. And there were contentions about some of these names. And in fact, the fact that some of these names are even, the positions are even blank. Some of the parties have submitted names of people who did not participate in the exercise or who did not win the primaries. Is there any explanation why INEC left this blank?
The Commission has not published the final list of validly nominated candidates. The final list of validly nominated candidates will be published by the Independent National Electoral Commission on the 20th day of September 2022. And that is for presidential candidates and National Assembly candidates. What the Commission has published as of today complies with Section 29, subsection 3 of the Electoral Act, which says that the moment political parties comply with the provisions of Section 29, subsection 1 of the Electoral Act in terms of the submission of its validly nominated candidates, that the Commission shall publish the personal particulars of such candidates in the constituencies where the candidates intend to contest election. In other words, for instance, for a senatorial candidate, if the senatorial district covers 3 local governments or 4 local governments, we will publish the personal particulars of such a candidate in the 3 or 4 or 5 local governments. So that is exactly what we have done. And we published the personal particulars of candidates that emerged from valid party primaries. And that is what the law says we should do. So if the name of any candidate was not published, or if the personal particulars of any candidate was not published today, the implication is that such a candidate did not emerge from valid party primaries.
So there is still a window for political parties to make amendment before you've published the final one.
Well, if a political party did not conduct party primaries, or a political party did not conduct valid party primaries, or a political party has submitted to the Independent National Electoral Commission the name of a candidate that did not emerge from valid party primaries, there is absolutely nothing the Commission can do. The only individual or the only person who has the local standard to intervene in such a matter is a candidate that participated in such party primaries. In other words, if 2 or 3 candidates participated in a party primary election, and a candidate believes that he or she won the party primary election and the name of a different person was submitted, that particular candidate can utilize the provisions of Section 29 of the Electoral Act, or Section 84 of the Electoral Act, or even Section 285 of the Constitution of the Federal Republic of Nigeria to seek redress. In that instance, and in that respect, and in that regard, the name of the candidate can now come in by a court order. But other than that, if you didn't submit the list, the name of a candidate that emerged from valid party primaries, the commission cannot bring in such a name thereafter. This is because what we did was that we gave the chairman of each political party an access code to our candidates nomination portal. It is that particular access code that the political parties used in uploading the list and personal particulars of their validly nominated candidates. And the portal shut down on the 17th day of June 2022. So we cannot reopen that particular portal. That portal will only reopen if a court of law makes an order that the name of a particular candidate shall be accepted by the Independent National Electoral Commission. Other than that, no person can come in anymore.
But on your schedule of activities, there is a provision for substitution of names.
You can only substitute the name of a validly nominated candidate. If a candidate was not validly nominated, then you cannot substitute such a candidate.
In the case of presidential candidates or vice presidential candidate,
yes,
that window is open because there is no primary or election process provided by law to get a vice presidential candidate into the race. So, I mean, it's usually the prerogative of the candidate to pick or to nominate a vice presidential candidate. So the prerogative is also on the political party to want to substitute whoever they think they wanted to substitute. So that window is still open, isn't it?
Well, as far as the law is concerned, and as far as the commission is concerned, the commission makes it mandatory that the moment a presidential candidate emerges, such a presidential candidate must nominate an associate who shall run with him or her as a vice presidential candidate. And so both of them are CMS twins, and they move together and they fall together. Now, in the forms submitted by the various political parties, they submitted forms relating to their presidential candidates, and they also submitted forms relating to their vice presidential candidates. And that is in compliance with the provisions of the Constitution and also in compliance with the provisions of the law. Now, there is a provision in the Electoral Act for withdrawal of candidates validly nominated. And the law provides that a political party cannot substitute a candidate that has been validly nominated except in 2 instances. If the nominated candidate dies or if the nominated candidate withdraws from the race. And in terms of withdrawal, the nominated candidate shall, in his own writing, write a letter to the political party that nominated him, indicating that he has withdrawn from the race. And that must also be accompanied by an affidavit, duly sworn to by the said candidate. Then the political party that nominated the candidate will now forward same to the Independent National Electoral Commission, saying that our presidential candidate has withdrawn or our vice presidential candidate has withdrawn. And these are the documents of withdrawal. And this is the person we are using to replace. But as of today, the political parties nominated their presidential candidates and nominated their vice presidential candidates. So the issue of withdrawal is at the discretion, an absolute discretion of the duly nominated candidate and no one else.
So INEC is unaware of placeholders because is now there's a birth of that new terminology into our political lexicon. there is what's now called a placeholder holding, because we have not made a decision just yet about the candidate for this position, but just hold, because that's the question again people are asking, that how come, or is there any punishment for political parties who submit to INEC names of people who did not participate at all in the primary, leaving out those who won the primary? Is INEC frowning at this kind of attitude?
Well, let me say this. In the forms submitted by the various political parties relating to their presidential candidates and their vice presidential candidates, what we have in those forms are the names of presidential candidates and the names of vice presidential candidates, and the particulars of those candidates and their sworn affidavit. None of the political parties indicated the fact that they were submitting a document in lieu, or they were submitting the name of a candidate in lieu. All the political parties that submitted the list and particulars of their candidates said they were submitting the list of their presidential candidates and vice presidential candidates. So the issue of submitting a name in lieu or submitting a name as a space holder does not even arise. But as I pointed out, the only way a candidate can go out from the list is if they're in case of death or in case of personal withdrawal by the person who has been duly and validly nominated and through no other means.
Senator Ahmed Lawan's name is not on the list. Mr. Mashina's name in Yobe Senatorial District was not on the list. So, I mean, we understand that APC submitted the name of Senator Ahmed Lawan, but INEC did not publish any name for that position in that senatorial district. Is there any reason why you omitted?
If you look at section 29, subsection 1 of the Electoral Act 2022, and incidentally, I have it here. What section 29 says is that it says that every political party, the onus is on the political party. It says every political party shall, not later than 180 days before the date appointed for a general election under this act, submit to the commission in the prescribed forms the list of the candidates the party proposes to sponsor at the election who must have emerged from valid primaries conducted by the political party. The commission does not submit the list of political candidates. It is the political parties themselves that have been given the locus to submit this particular list. And in this case, there is no personal interface between the commission and the political parties. We opened the portal, what we call a candidates nomination portal, and we gave an access code to the national chairman of each of the political parties that conducted primaries, with which they uploaded the list and personal particulars of their nominated candidates. So if a political party has uploaded the list and personal particulars of a candidate that did not emerge from valid party primaries, the Independent National Electoral Commission is not under a constitutional or legal obligation to publish the particulars of such a candidate.
So a reason, that's probably the reason. Now, the question is that, let me ask quick question, two quick questions before I now go to the substantive question that I'd like to ask. The first thing is that INEC only recognizes primary that you observed, isn't it?
The commission recognizes valid party primaries, political party primaries that were conducted in accordance with the Constitution, in accordance with the Electoral Act, and also in accordance with the guidelines and regulations of the various political parties.
Now, do you compare the primary that you monitor and the list of the candidates submitted by the political parties?
Well, those ones are within the internal realm of the Independent National Electoral Commission.
But is that a standard procedure for INEC?
We have our own standard procedure.
For verification?
We have our
Should the political parties not align with the standards in which you have set for monitoring the primaries? Because the reason why I'm asking the question is that a lot of the times, and which of course in these cases that we have seen, INEC will monitor a certain primary, and there is a parallel primary going on elsewhere, and there are confusion. In the case of Godswill Akpabio, we understand that there was a call for a reconduction of the primary, and it was conducted somewhere else, and perhaps INEC was in another place and all of that. So there are this confusion, and perhaps the reason why Godswill Akpabio's name was not present on the list. But the question again is that there are names that are being present on the list submitted by political parties against what INEC monitored on the ground.
Section 82 of the Electoral Act makes it mandatory that every registered political party that wants to conduct primaries must give to the Independent National Electoral Commission 21 days notice of its intention to do so. And such a political party shall tell the commission the venue where the party primaries will take place and the date when the party primaries will take place. Now, if for any reason the political party is unable to secure a particular venue, or for any reason it wants to change date, the political party shall give to the Independent National Electoral Commission 7 days notice of its intention to change. So if you have given the Independent National Electoral Commission a date and a venue, and we go to monitor such party primaries, and then we issue a report, or we write a report relating to such party primaries, and then you go again somewhere else, not to the notice of the Independent National Electoral Commission, to go and conduct something else that you call party primaries. Of course, whatever you have done there cannot be said to be a valid party primaries within the contemplation of Section 82 and Section 84 of the Electoral Act 2022.
So how do you resolve the names that you left open and blank? There are primaries conducted, party did not submit the right name, and you did not publish any name. How do you resolve it?
Well, what the law has said is that any person who has any complaint relating to the conduct of party primaries, relating to the names of candidates that have been submitted, and also relating to possible violation of the Electoral Act or the rules and regulations or guidelines of a political party can seek redress before a federal high court.
All right, let's go, because we spent a good time on that matter. The implication, because any decision of the court on any law, extant law guiding our election, and even the ones that affect your guidelines, because that also, the Constitution has empowered INEC to set up a guideline for every election that it conducts. So if anything affects those laws and those rules, then there are implications. For the ruling and the position of the Supreme Court today, what implication does it have on INEC?
The political parties have already done their congresses, have done their conventions, and they had already made a decision on who should be voted for and who should not be voted for, and who should be a delegate and who should not be a delegate. I think that some of the political parties were properly guided and decided that it was in their best interest to err on the side of caution by not allowing a certain category of political appointees to either be voted for or to be voting delegates. So I think that we have passed the stage of congresses and conventions, and the political parties have complied with the provisions of the law. And if any aspirant, for instance, believes that any provision that his or her political party did not conform, or that if his political party violated any of the provisions of the Electoral Act, that such an individual has the right and the locus to challenge such an action before a court of law.
So there won't be any retroactive effect of this position of the Supreme Court, because, of course, the subsection 12 of Section 84 of the Electoral Act is talking about congresses and voting delegates and all of that eligibility of a voting delegate or aspirant. So that as passed will move forward. So there is no retroactivity of that.
The law is the law. Section 84 of the Electoral Act came into force the day the president signed into law. So nothing has happened to change that particular situation.
So for sure now, INEC is convinced of a possibility of extend the deadline of CVR, the voter registration exercise.
The chairman has been very clear and has been very consistent that the commission is disposed towards extending the date for the continuous voters registration exercise. But we can only do so at the conclusion or determination of the case that is pending before the Federal High Court. We are going to go before the Federal High Court on the 29th day of this month to put the cards on the table. And we are convinced that after we make arguments, that the court will be convinced on why we cannot extend the CVR beyond a certain period. But we are convinced, given the enthusiasm of Nigerians, given the new resolve of Nigerians to register, that an extension is inevitable, and we are definitely, the commission is disposed towards extending the period for the CVR, but not up to the period that some people are canvassing.
Beyond the adversarial debate in the court, in the precinct of the courts, yes, come to the level of advocacy. Those who are saying, we're not fighting you, we're not even holding you into them, taking you to court over this matter. Yes. We're saying, for the sake of those who need more time, the House of Reps are also seeking INEC's mercy to extend this. Are you also looking in that respect beyond the adversarial contest that is going on in the court?
Definitely. The commission is convinced that getting more people into the voters' roll will add value to the electoral and democratic process. We want as many people as possible to be in a position to register and show up on election day and vote. And for those who have lost their PVCs, we want a situation where they can replace their PVCs. For those whose PVCs are defaced, we want them to replace them. For those who want to transfer from one state to the other, or from one local government to another local government, or from one registration area to another registration area, we want them to do all these things successfully. But we also want a situation where these things can be done, and then we'll be in a position to clean up the voters' register, to do claims and objections, and also to print the permanent voters' cards of the registrants and get them to collect these things. It will be a futile exercise to extend the period to an unreasonable time, and then at the end of the day, be unable to print the permanent voters' cards of these new registrants and get them to collect these cards. Right. We want them to collect these cards, and we also want them to show up on election day. So we are favorably disposed to an extension of the CVR.
I just have like 40 seconds to break. I'm due for a break, but Edo State PDP candidates' names were omitted. They're not. Is it because of a court? Yes, I think there's a court order relating to the list of and personal particulars of PDP candidates from Edo State, and we have a history of obeying court order. All right. So, lastly, does INEC have the power to reject candidates that did not emerge from the primary?
I don't think it is fair for me to answer that question. If you look at Section 285 of the Constitution, you look at Section 29 of the Constitution, and you also look at Section 84 of the Electoral Act, I think you can find the answers there. The Constitution, Section 285 of the Constitution of the Federal Republic of Nigeria, makes it very clear that if a political party complains or is not happy with the decision of the Independent National Electoral Commission relating to the rejection of his candidate, that such a political party can go to court. So the answers you are looking for are embedded in the constitutional framework and also in the Electoral Act. We will continue to act in the best interest of the people of this country, and also in the best interest of our democracy, and also in conformity with the Constitution and the Electoral Act.
So you don't have a yes or no answer, whether or not you have the powers to reject anyone who does not emerge from the primary?
I'm saying that our powers are embedded in the Constitution.
It's in the affirmative.
And we will continue to exercise the powers donated to us by the Constitution. And those powers that have not been donated to us by the Constitution, we will not exercise them.
Mr. Festus Okoye, I must sincerely thank you, because I called you out in the very close timing to this program. Thank you so much for honoring the call. Thank you so much indeed.
I appreciate this opportunity.
We'll take a break. And when we return, there are more implications to what has happened today in the Supreme Court, when President Buhari and his Attorney General went to court. But the Supreme Court said, no, abuse of court process. We hear perspectives to these implications, and of course, we'll be getting some views on what is happening in the Supreme Court. There is a revolution and there is a revolt by some justices against the CGN about the processes and the conduct of affairs in the Supreme Court. We hear from legal minds. Join us again, everyone. Everyone for staying with us right here on the program. There are very critical matters that we're taking up tonight, such as the Supreme Court verdict or position of the Supreme Court when the President and the Attorney General have gone to the President, approached the approached the Supreme Court to seek clarification on Section 84, subsection 12 of the Electoral Act, but the court said it's an abuse of court process. Let's get some legal perspective to this one. I'm being joined by a senior advocate of Nigeria, Mr. Paul Ananaba. Is with us virtually on the program. Thank you so much, Leonard Sig, for your time tonight. Give us a sense of what the outcome of today's Supreme Court sitting means, especially for our electoral jurisprudence, and of course, for those who are following closely how this drama has played out between the National Assembly, politician, and the presidency.
Yeah, thank you, my brother, and good evening, Nigerians. The point is that I had in this studio, when that action was beginning, stated clearly that there was nothing wrong with Section 84.12 of the Electoral Act. And I'm happy that the Supreme Court came to that conclusion too. The issues are very clear. By Section 232 of the Constitution, the original jurisdiction of the Supreme Court was stated clearly there. And it is about the federation and the states, or between the states and the states when there are disputes. And suddenly there's an action where the president now sues the National Assembly. So you will see that it's not a competent suit. Now, Section 84.12 has nothing to do with the president. It has nothing to do with the president. It has nothing to do with the federation. It's just a simple provision of a legislation which the president signed on the 25th of February this year. So today is 24th. So it is even less than 4 months. And we've already gone to Supreme Court and gotten a judgment. So that's the point. The Supreme Court is saying the action is incompetent. It's an abuse of process. And when you hear abuse of process, it has many dimensions. It is when you file an action which is improper, you have abused that process. One of them is forum shopping. Assuming that there would have been need for such action, it would have been action filed by those affected, those political appointees by Section 84.12. Those are the people who could have gone to court. And if they had gone to court to challenge Section 84.12, then it wouldn't have been an original suit, a suit where the Supreme Court has original jurisdiction at all. That's what the Supreme Court is saying. So asking the Supreme Court to apply the blue pencil rule and strike out Section 84.12 cannot hold water. Now, what that simply means is that this is in excess of the legislative competence of the National Assembly under Section 4 of the Constitution. It is not. The Supreme Court is saying the National Assembly has powers to make laws. The presidency cannot dictate to the National Assembly on how it makes laws. So gradually we are going deepening our democracy by judicial interpretation, which is what many of us have been urging, that the Supreme Court should step up, our courts should step up and give this type of judgments that deepens our democracy. Now, what is the intention of this?
If I may jump in quickly so that we can advance the conversation in bit after bit. Now, when we wonder, let us glean from your years of experience in the bar. When we wonder that it is track law fundamental the original jurisdiction of the apex court, the Supreme Court, and what you have mentioned, the contradictions that the state between state, federal government between states, and arms of government and the other, and how the position, the premise in which you can approach the court of government, or the presidency can approach the government. So when we wonder, at what point is it embarrassing for you? I'm trying to put it in a very nice way. Is it embarrassing for the Supreme Court, for a case that went from the Attorney General's office to the Supreme Court, and the Supreme Court had to say it is abuse of court process? So that's why I'm asking, is it not trial law? Is it not fundamental? Is it not basic principles of law? Some of these issues that the Supreme Court highlighted and threw back to the plaintiff.
I will not pass my own judgment over the judgment of the Supreme Court. I will simply end where the Supreme Court ended, which is where the Supreme Court said it is an abuse of process. Now, it is less for those who who filed the action to know whether it is commendable for actions from such an exalted office to be an action the Supreme Court considers to be an abuse. It gives concerns, it gives cause to worry, but we will keep on track. We will not leave the direction at the track. The point is that action shouldn't have been filed at all. Now, I was going to make a point that already parties have already had their conventions, primaries, and it is what would have been the effect of the Supreme Court dabbling into that and striking out a legislation that is less than 4 months old. What sanity does it bring? The president signed this electoral act. It has not been given any chance to operate. And there is already a suit at the Supreme Court to do away with that section. So these are the issues to look at. And if you look at it, the conventions and the primaries went smoothly and became a lot more manageable because the issue of political appointees and the level playing ground was installed. And that is what you gain from practicing democracy and getting the courts to interpret. And then we make progress. Now it's over. The electorate are now the people voting in the delegates. And that's what it should be. And not for political appointees in their roles. By the time you are competing with an incumbent, his appointees are already there, you are already disadvantaged. And I made that point some weeks back.
All right. So, Mr. Ananaba, so I would like you to take us through the process that you think should have the executive, if they wanted anything changed, what they naturally should have done in the process of lawmaking. Before you go into that, you see what is happening in the National Assembly, where a lot of the lawmakers are now jumping ship because of the grievances that the Electoral Act has done to their career, some of them who could not get tickets. Can you touch on that implication? Because this section, ab initio, the origin of all of this is that some of these lawmakers were afraid of the powers of their governors in the different states to determine who goes back to the National Assembly or who gets the ticket. So they wanted to fight that process, but it does look like they were not successful in doing that. Now there are implications of that, and now they are revolting and leaving their political parties because a huge number of them did not get a ticket, and it's obvious they are not returning to the National Assembly. Can you touch on that?
Yeah, you are right. In constitutional democracy, there is a jurisprudence that evolved in the United States called JOI. It is the jurisprudence of the original intention. So if you get into the jurisprudence of original intention in this instance, you come to where you were. That is, this is why the National Assembly members put this. But don't forget that the National Assembly alone did not make this law. It also passed through the presidency, and the presidency raised objections, got satisfied, and assented to it. And that's part of what the Supreme Court is saying. You just assented to this legislation a few weeks ago, and you are coming back to say, you also who assented, you're saying, no, it should be removed. That's the point. Now, yes, members of the National Assembly will also need time to, I used to hear the language, nascent democracy. Our democracy is deepening. People should know that laws should not be made because of particular instances. And because someone is dissatisfied, there's a jumping. And you should also see that the Electoral Act has also clipped these jumpings. That jumpology is not helpful. So I see going forward, our political parties developing along ideological lines. So you don't just move from being a Democrat today to become a Republican. It's not helpful to the country. So when we want to choose leaders, we know, okay, this is what this person is likely, where this party was likely to do, and which party to go to. Now, the fact that many of these people lost their seats is a political occurrence that will continue to come. So, whichever way they had gone about it, what is important to the average Nigerian today should be, we now have some more degree of sanity in our primaries. You no longer have the several thousands of people that will come for the primaries. What you now have is a few delegates, and it will mature further to these delegates becoming well-chosen persons, and not just increasing delegates by having more political appointees. So that's what I take from that.
Of course, some of the lawmakers may be licking their wounds, just to use that word. Some of them biting their fingers now because of what has come out of that. Some regretting that maybe they should have thought differently, and this perhaps backfired. Because in some of the political parties, for example, we understand that there is an agreement that the governors, those who are seeking a return to office, will get automatic tickets. But some of these lawmakers couldn't get that bargain, and they have lost out. And there is a huge turnover in the National Assembly. Do you think that some of them who probably narrowly get back into the National Assembly what lesson do you think they would have taken out of this? And what perhaps, with this huge turnover, what impact will it have on the quality of legislation? Because considering the history of parliamentary politics world over, or parliamentary democracy, experience also counts in the quality of legislation.
Yeah, thank you. Will the politician learn lessons? I doubt. The lesson the politician will learn is what brings him back or her back to the office at the next round of election. I think that's the only lesson the politician wants to learn. The same set of people, you play them again, and they think that's a self-serving interest, they go for it. But coming to the effect of having majority or having a large percentage of the legislators being fresh and new persons, it is actually a challenge. That is not the way the democratic process is fashioned. You see, you hear the word ranking senator, ranking member of parliament. There is experience. There is experience, and experience is necessary. Even in our organizations, there are institutional memories. There are precedents. And many of these newer ones are going to take time to to come to terms and acclimatize with the parliamentary behaviors, parliamentary conduct, and that will take it in so much time. But if you have new but the older ones are in a majority, or you have a good number of them, it helps them to learn fast. We used to have a proverb that if you go to a meeting where new members are more than the old ones, it is difficult to run the meeting because the new ones will vote in the manner they think without actually carrying the institutional memory and history as to how to go. So it is not very helpful to Nigeria as a country. I believe that there is need for us, the political parties should look at it as they carry on politicking, that we should not have very high turnover of legislators. New legislators, it is not helpful.
Okay, so two quick questions before we close the program, Leonard Silk. The first question before the last will be the lessons for the presidency and the Attorney General office, and perhaps if you can put us through what naturally should have been the standard procedure to go through instead of going through this route. If you do not like a section of the law in getting it fixed, the process of our legislation, lawmaking, what should have been done? Just if you can quickly do that for us.
What I think should have been done is to introduce an amendments bill, and then it goes through the lawmaking process, the first reading, second reading, third reading committee, and all that, and that would have been more helpful. The reason is that it would have given Nigerians and their representatives more opportunity to have a second look. And it wouldn't have been so rushed. But I think that the thought may have been that the court's pronouncement, particularly at the Supreme Court, once as a pronouncement of the Supreme Court, would have been faster and quicker and more permanent. So I think the lesson has been learned, and as the country continues to move on, subsequent governments will know that perhaps it would be better to go back to the legislature, because Section 4 of the Constitution is still there. The legislature that has the power to actually make laws. Yes, by pronouncements and the realist jurisprudence is what they say that is a law, but the judges are not legislators. They are not there primarily to make laws. So I think that lessons have been learned. All things being equal, but in subsequent, even in some states, I think that the law making procedure for amendments, that's why you have amendment of laws, will be better than judicial interpretation. Judicial interpretation will look at the law as is and interpret. Amendments will give more opportunity for hearings, for objections, and before it goes through.
All right, let's close on this note, and perhaps quickly, Leonard Silk, the position of the NBA, the statement from the president of the Nigerian Bar Association, Olumide Akpata, it says before these justices of the Supreme Court could pen their frustration, it must have been that there is something that have gone wrong badly, and you saw the agitation by the Supreme Court justices in what is happening in the judiciary, the incapabilities that they have experienced and in carrying out their duty. Is this a watershed for the judiciary? And where do you think that the judiciary or the Supreme Court will go from here?
Well, I'm not aware of any time the justices of the Supreme Court had written in that manner. But it's important that we know that the judicial system, regulates itself. There's the NJC, and all that. Many other bodies, body of interest and all that come in to look at the judicial framework from time to time. I would think that for a justice of the Supreme Court to write, and then in this instance, more than 10 of them wrote in writing, making complaint, it should be taken seriously, but it should not be taken out of context. It must be that they have genuine concerns. And I agree with my president, Olumide, that it is not something to joke about, yes.
Lionel Sik, Paul Ananaba, Senior Advocate of Nigeria, thank you so much indeed for your thoughts tonight. I really appreciate it.
Thank you.
And that's how we end this Friday's edition of Politics Today live on Channels Television. Many thanks to everyone for watching. Until I come your way again on Sunday at 8 p.m. Have a wonderful evening, everyone.